Good afternoon, everybody. This is Jennifer Schaus, and we're coming to you live today from Washington, D.C. Thank you for joining us in our webinar series. And today we are covering COVID mandates in our COVID contracting series. Today's session is being recorded. The recording and the PowerPoint slides will be on our website and on our YouTube channel. Hopefully within the next 24 hours, it'll probably be shorter than that. So if you have registered for this webinar, you'll get a copy. You'll get an email with a link to the recording as well as the PowerPoint, and you'll get our speakers' contact information as well. Okay, just a quick blurb about us. We're based in downtown DC and provide a variety of services for established federal contractors. We work with product, service, and software firms, primarily helping them get onto the GSA schedule. Some other services are listed here on the slide. You can also hop over to our website to learn more about us. And also you can find over 500 webinars on our website. They're categorized there by topic, and you can also find them on our YouTube channel. Just a quick announcement that we are back to in-person networking after a 2-year hiatus. For about 15 years, we hosted networking events at the Kennedy Center, which is Washington, D.C.'s premier venue for the performing arts. So on Monday, March 28th, we already have over 100 people registered. We've got our GovCon Spring Soiree. The registration link is there at the bottom, and we still have a couple sponsor tables available. You can also register for that on our website under the events section. A couple other webinar series that we are hosting this year. On Wednesdays at noon Eastern, we have the FAR supplement webinar series. Yesterday we covered special ops. Next week we're covering Transcom, and the series runs through August 24th, closing out with the Veterans Affairs. These are complimentary and recorded. If you've missed any of the early ones, which covered a lot of DoD, you can find those on our website under the section called FAR Supplements. And then on Fridays, we host a corresponding playbook, which is more of a strategic and tactical look at the agency. So tomorrow we're covering special ops because we covered the FAR supplement on special ops on Wednesday. So tomorrow we'll talk about contracting trends over the last couple of years, contract opportunities that are coming up, acquisition forecasts, set-asides, and how they played out within each of the departments or agencies. Full schedule, the recordings, the links to sign up are on our website under the section called Playbooks, and those are on Fridays. Okay, so today's session is in our COVID contracting series, and our topic is what federal contractors need to know about COVID mandates. First, we want to thank our sponsor, which is Dastin. And Dastin is an IP and cloud solution provider working with corporations, military, and government agencies to lower their cost, increase scalability, improve operational efficiency, and meet compliance regulations using targeted cloud-based solutions. They're a certified partner of Oracle NetSuite, a premier tier Google Cloud provider, and a certified partner of Cisco, Virtue, AODocs, and Authenticate. They've got an easy-to-use software and robust functionality for the 5 most critical KPIs for GovCon, both in backlog, pipeline, EAC, DSO, and wrap rates. For more information about Dastin services, Dastin services, or to schedule a consultation, you could just email Joe Alston. You've got his email address at the lower right-hand corner of your screen. So thanks again to Dastin for their sponsorship. Okay, let's start to dig in here and cover today's topic on COVID. We want to thank our speaker, Ms. Gray Mateo-Harris. And Gray, I will be quiet and let you take over here. I'm going to put myself on mute, and the floor is all yours.
Thank you so much. Really appreciate the brief introduction. I'm excited to be with all of you today, talking about what federal contractors need to know about COVID mandates. My name is Gray Mateo-Harris. I'm an equity partner at Fox Rothschild. Fox is a national firm with over 30+ offices across the nation, including an office based out of DC, which does host our federal government practice group. And I serve as Chicago office regional practice lead for labor and employment law and co-chair of the Trade Secrets and Restrictive Covenants practice group. I also co-chaired the DEI initiatives across the firm and work with clients that have DEI needs in addition to traditional labor or employment litigation and counseling needs. One of the areas that has been pretty heavy and difficult for clients to navigate has certainly been how to interact with COVID-19, dealing with business impacts, and also dealing with public kind of pressures as to how to address various issues while keeping businesses running, staying in compliance with applicable laws, and certainly maintaining a happy and engaged and productive workforce. So I fully understand this remains a hot topic and will be for the foreseeable future. If you could please move to the next slide, Jennifer. So today we're going to generally cover the history of vaccine mandates that happened prior to COVID. We'll talk about the executive order on requiring coronavirus disease vaccination that applies to federal contractors. We'll cover the OSHA ETS, which of course is another hot topic and recently changing. And we'll go over some practical considerations for employers, and this would apply to all employers that have to manage employee requests for accommodations and the like. And of course, we're not going to get through every single slide and all of the content I have here for you, but I did include what I thought was really important and just some tidbits that maybe you'll want to go back to and evaluate as it relates to your particular workforce. Next slide. So vaccine mandates, are they legal? Yes, they are, but there are a whole host of considerations that need to be taken into account, and as federal contractors, there are extra restrictions and expectations. Next slide. So we'll go over the guidance that is out there from the EEOC, OSHA, as well as federal, state, and local laws to watch out for. And of course, we know state law is especially changing on this topic every day. Next slide. So what has history taught us? Although it seems like the first time for a lot of us, this really is not. So we've dealt with other, albeit very different, pandemics in the past. And we know that the US government has the authority to mandate a vaccine. Mandatory vaccinations were allowed prior to COVID-19. The first time was in 1809 for the smallpox pandemic. And in 1922, the Supreme Court upheld childhood school vaccination mandates, which is now settled law as it relates to polio, measles, mumps, and a whole host of other diseases. There are no laws that actually prohibit employers from requiring vaccines prior to those that have been enacted recently at the state level. Next slide. So we know the pandemic preparedness in the workplace and ADA guidance in 2009 started looking at what we needed to be considering and thinking about when there was a pandemic. And that was issued around the same time as the H1N1 flu, which was anticipated to be quite a horrific pandemic, but truly never materialized to the level that we are seeing today with COVID-19. So we have the swine flu pandemic where in 1976, President Ford had to mandate vaccinations, and in 2009 again with the H1N1 vaccines. The EEOC has ruled previously and continues to take the position that employers couldn't compel employees to take a flu vaccine unless there were medical and religious accommodations. So while this is novel, the kind of logic and the issues continue to be the same, at least from the EEOC perspective. As to OSHA, employers could mandate vaccination, except that they had to make those allotments for employees who had a medical condition that, of course, required that they have an exception, and certainly we've seen whistleblower type protections for employees who do not want to get vaccinated for a reasonable belief as to their medical conditions. And OSHA, again, is not new to that particular area, but the COVID-19 pandemic has turned everything on its head. Next slide. So the executive order was issued by President Biden back in September 2021, requiring COVID vaccinations for federal employees. And the national strategy focused on vaccinating those that were not already vaccinated protecting those that were already vaccinated through things like boosters, keeping schools open, increasing testing and masking, protecting the economic recovery, which is of course very important to all businesses, and improving care for those that have COVID-19. Next slide. It had two main components. One, that all federal contracts that were executed after October 15th, 2021 had to comply with the Safer Federal Workforce Task Force guidance, which mandated vaccination for contractors and subcontractors. And then two, private employers that had over 100 employees had to comply with what would be issued in the future at the time by OSHA. That was the Emergency Temporary Standard that I'm sure everyone has heard a great deal about. Next slide. So the guidance that was issued on September 24th really focused on the fact that covered contractors had to ensure that their contractor employees complied with various workplace safety protocols. They had to actually provide COVID-19 safeguards to ensure that employees that were performing work on a federal government contract or similar instruments were taking precautions to reduce the spread of COVID-19. The contracts that were executed after the applicable date had to comply with all guidance issued and published, and the goal again was to decrease worker illnesses, absences, reduce the labor costs associated with such issues, and improve efficiency. Next slide. So some of the safety protocols, as we all know, is COVID-19 vaccination, which of course had to be subject to any entitled accommodations. But in addition to the COVID-19 vaccine, there are requirements as to masking and physical distancing, as well as the designation of one individual to coordinate all workplace safety efforts. This applied to contractor employees and the subcontractor employees as well. Next slide, thank you. Here are some definitions so that you can see where your workplace fits in here. I won't go through them in depth, but again, it helps put in context how broad the language was and how it expected to really attach to anyone who would be performing work on any instrument that related to federal work. Next slide. Next slide again. Contractors were required to actually review employee documentation to establish that vaccination requirements were actually met. And some of the sample forms they could obtain were a copy of the actual COVID-19 vaccine form issued by the CDC, an immunization record from a healthcare provider or pharmacy, medical records generally documenting the vaccination, information available through a public health site or a state information system, and a copy of any official documentation that verified such status. Next slide. They were also encouraged to implement vaccine requirements for their non-government employees who were going to be performing work at the same location but are not otherwise working on a federal contract. So the goal was to reach as many employees as possible, even though those may not actually have been providing work on a federal contract. Contractors were also required to provide an accommodation to an employee that communicated they were not able to be vaccinated because of a disability or a sincerely held religious belief. Contractors were required to review what accommodations would be reasonable, and they needed to treat them in accordance with applicable law. Next slide. They were also required to review what accommodations would be available, as would be typical for an ADA or other such request, as well as a Title VII request. And we will cover both of those later in this presentation. They also had to ensure, though, that beyond COVID-19 compliance, there was compliance with masking and physical distancing as to those that are not vaccinated. The agency had exceptions, or federal agencies had the option to have exceptions applied if they really needed the work to start sooner, but the contractor could not ensure vaccination. And that's just a note here to see where that would have fallen. But at the end of the day, employees had to be vaccinated within 60 days of starting work. Next slide. They also had to comply with any published CDC guidance, which, as all of us know, have changed constantly, gone forward and backward as to masking and physical distancing. And we expect it to continue to be fluid and there to be further changes down the line as COVID-19 rises and falls with variants and other such issues. So in areas of high or substantial community transmission, the expectation was that those that were fully vaccinated would still wear masks except for some exceptions, and contractors had to review and follow the CDC COVID tracker to adjust every week to what would be appropriate in their environment. And this really has been something that's continued to develop, and for many contractors across the country, those transmission levels are really at a low figure now that doesn't require as much as before. Next slide. All right, those contractors that are requiring folks to wear masks had to ensure they were wearing them correctly, meaning they were covering both their mouth and nose, they were using appropriate masks, there were needs to ensure that outdoor crowded settings as well as activities that involve sustained work were all being handled in consistence with the CDC guidance at the time, which again, we understand has changed depending on the community spread. Next slide. They could provide for exceptions as to mask wearing and physical distancing, and that would depend greatly on your workplace. So if an individual is able to kind of be alone in their office with a closed door, if an individual is going to be eating for a short while, keeping appropriate distancing, masks could be removed. If an employee is working in a way that the mask would get wet and pose a danger, then certainly that could be an exception. High intensity activities that would make it very difficult for workers to continue to wear masks, and any kind of health or safety risk determined by a workplace risk assessment would allow a contractor to remove the masking requirement for certain individuals. Additionally, fully vaccinated individuals were not required to physically distance themselves, and that remains true. Unvaccinated individuals, technically under the guidance, are still supposed to keep a distance of 6 feet from others. Although again, we understand that in practical reality, these requirements have been greatly slowed, given that most of the country is now under a low community transmission. Next slide. Again, the fact that contractors had to designate someone to coordinate efforts remains in effect. And that is important to ensure that all the communication was consistent, that the communications were all in line with required and applicable law and regulations, and that folks would have someone to come to for questions and guidance. Next slide. Again, they were required to ensure the posting was done appropriately and ensure that employees could comply with their vaccination submission of materials. But at this point, we know that there have been multiple injunctions as to various provisions, and the extent as to which those non-vaccine related mandates are enforceable is a little bit unclear, but we expect, and the guidance that's been issued so far suggests, that non-vaccine related mandates remain in effect and are likely to remain in effect, but those vaccine related mandates have been enjoined. So again, depending on your particular workforce, you may be in a state where the injunction is not really in effect, and there are applicable state laws that may require you to do something differently as to vaccine mandates. You may also be in a state that prohibits any vaccine mandate. So we'll tackle that next. Next slide. OSHA also issued guidance that was specific to healthcare entities, and those were also challenged. We see that the interim rule issued in June 10, 2021, as to the emergency temporary standard requirements for those in healthcare setting, and then the general guidance for those that were not in healthcare settings have been in effect for some time now. The guidance was updated in August to reflect CDC changes, and we expect guidance to continually be updated as appropriate to match CDC's ongoing changes. And again, unless required by specific federal, state, local, or other laws, rules, or regulations, most employers are not required to take any extra steps to protect fully vaccinated workers who are not otherwise at risk, at least under OSHA's purview. Next slide. OSHA has the authority to issue temporary regulations if there's a grave danger and they determine that COVID-19 poses a grave danger. Next slide. However, the Supreme Court disagreed that they were appropriate in acting with such broad regulations. The ultimate ruling suggested that specific occupational dangers would be something that OSHA could regulate, and that perhaps had there been more limitations, such ETS would have been permitted. So a specific quote is added here, but it is just showing you that the fact that workers all have risk because they're workers wasn't enough for OSHA to issue such a broad mandate. Next slide. So again, as originally formulated, the ETS is not in effect, and we don't expect it to be. It did cover those with 100 and more employees and required them to have mandatory vaccination, or in lieu of vaccinations, they needed to do weekly testing. And at this time, it's not being implemented. Next slide. That being said, OSHA has not given up on this effort, and they have certainly withdrawn the emergency temporary standard, but not the ETS proposed rule. And they are continuing to prioritize resources as to a final and permanent COVID-19 healthcare standard that would apply in years to come. OSHA has the ability to regulate COVID-19 measures if it does pose a special danger or is an occupational hazard. So for example, in certain positions where they are working in crowded environments, it could be that OSHA will ultimately mandate some form of vaccination. We don't know yet, but that is what they have communicated is likely to happen. Next slide. Again, Secretary of Labor Walsh stated back in January of 2022 that OSHA will do everything in its existing authority to hold businesses accountable for protecting workers, including under the COVID-19 National Emphasis Program and General Duty Clause. So they basically are making clear that just because the ETS is not being enforced as written doesn't mean that OSHA's commitment remains the same under their already existing authority. Next slide. And what they're referring to is the General Duty Clause, which allows OSHA to ensure compliance in protecting employees and ensuring that employers provide a work environment that is free from any recognized hazard. Next slide. And the National Emphasis Program has to do with a focus on those employees that operate in high hazard industries. So again, it's targeting establishments that have workers with increased exposures. So hospitals and assisted living facilities are some examples of places that are expected to have higher risk for employees. Also places that have had outbreaks and a high number of COVID-19 related complaints and cases are going to be under the microscope for OSHA. Workplaces where workers are in close proximity and have to be. Again, meatpacking plants have been one area that have really gotten a lot of attention, warehouses and the like. And they're going to continue to prioritize investigating fatalities involving COVID-19. So employers are not off the hook. This is clearly still a central mission for OSHA, and we expect them to continue to enforce their authority in this space. Next slide. So again, they might have targeted regulations, they might have a new emergency rule, or they might have final rules, but we know that the infectious diseases rule is already on the regulatory agenda, meaning they're actively working to have a rule that will target infectious diseases such as COVID, but also shingles, measles, TB, and others. Next slide. So again, this is just a slide to think about the best practices. So now we know the ETS is not in effect, but OSHA has told us what they think are best practices and what they think are minimum requirements to keep your workers safe. So as employers, we know that we should certainly not do anything that goes against supporting vaccination. So things like discouraging employees to get vaccinated or actively impeding efforts to get vaccinated, those would be looked at negatively by OSHA and other bodies. Prohibiting face coverings, so employees that want to wear face coverings should not be prohibited from doing so unless it poses some kind of a danger or is otherwise an issue that you have a legitimate business reason to take on. Testing employees, so to the extent you can offer testing for unvaccinated employees or at least encourage it, that would be viewed positively. Verifying vaccination status, so whether or not you're in a state that allows you to collect information is a different issue. If the state is not allowing you to collect it, that's fine. If you are allowed to collect it, then certainly keeping that information confidential and continuing to keep track of how much of your workforce is vaccinated, those are considered positive steps. Providing information to employees about vaccines and about your policies that encourage it, about their legal rights, all of these are considered positive. And then, of course, not mandating that employees return to work if they're sick or if they're infected, unless you're in a business where there is, reason to think that they are such essential workers that they can come to work even if infected, consistent with CDC guidelines. But generally, if you have an employee that's sick and does not want to come to work and can verify they are infected with COVID-19, OSHA would look at your workplace negatively if you force that employee to come and there was a spread or any other issue. Next slide. Again, OSHA has always had mandated reporting, so that's not new, but this is a reminder that any work-related COVID-19 fatality has to be reported within 8 hours of the employer learning about the fatality, and any work-related COVID-19 hospitalization has to be reported within 24 hours of the employer learning about such hospitalization. Next slide. There are serious fines for any violations. A maximum penalty for a serious violation is $13,000 per, which can be significant if you do have a breakout of any kind. And then there's a maximum penalty for a willful violation, which is a higher standard, and that's $136,000. So again, that is a serious number, and OSHA has begun issuing such fines and has had a long history of issuing them as appropriate. Next slide. There are 22 states that have their own OSHA-approved state plans that cover private and public sector employers. In those states, the state and not OSHA enforces workplace safety regulations. Otherwise, OSHA is the entity in states that don't have their own state plans. Again, any state plan may have higher standards than those implemented by OSHA. And it is important to keep that in mind because they may issue their own specific standards that you have to comply with. Next slide. Again, I mentioned this earlier, but there are some states that are prohibiting employers from mandating vaccinations and where they are allowing unemployment compensation if separation is based on a refusal to comply with a vaccine mandate program. And they're requiring broader accommodations based on prior infections or personal objections to vaccines, not just a religious belief or a medical reason. And then there are other states that are actually mandating vaccines in certain workplaces or mandating masking in certain circumstances. Next slide. Again, I just added some states here. This is not a complete list, but it is, to my best knowledge, the updated list. And just something to refer back to, see if you have operations in any of these states, and then evaluate how those restrictions apply. Of course, we know with COVID numbers being at a low level now, many states are allowing their restrictions to lapse or are not planning to renew them when they do, although that's not true for all of these. Next slide. Again, not a complete list, but these are states that are requiring vaccinations. And again, this is varying greatly. Some states are specific to a category of employee or to a part of the business. Next slide. So what is something employers can do to encourage vaccination without running afoul of any applicable laws? So paid leave continues to be an option, which is ensuring employees have paid time off to get vaccinated, to recover from any adverse reaction to a vaccine or a booster shot, and allowing them to have the time off to quarantine or isolate as needed. Federal law does not provide any required paid time off, but there are state or local laws that may actually require paid time off or sick leave that can be applied for in connection with any vaccine-related side effects or illness. There are at least 20 states with some form of sick time to consider. So again, depending on where your operations are, you'll need to make sure you're in compliance with those various states. Next slide. There are other compliance issues. For example, do you have a collective bargaining agreement in your facilities that mandates anything outside of management rights clause? So perhaps there are some rules or agreements as to what will be done with respect to things like employees having an absence policy violation because they're missing a certain number of days because they can't come to work due to not being vaccinated or due to whatever other issue might apply. So you'll have to definitely, look at your collective bargaining agreements, see if there's anything special required there. You'll have to look at wage and hour considerations. Are you having employees that take time to get vaccinated? Are you treating that as working time? Based on your state, should you be treating it as working time? Are you requiring testing at work? And if so, are they getting paid for that time or not? And who is paying for the actual COVID test? Is that something you're providing? Are employees incurring that expense out in the marketplace? And if so, are you reimbursing them? Are you providing masks? Are employees required to have their own masks? If you're requiring a particular type of mask, are you reimbursing that? Long COVID as a form of disability under the ADA or a serious health condition under the FMLA, Family Medical Leave Act, and ADA being the Americans with Disabilities Act. So again, because long COVID has emerged as something that is going to affect and continue to affect various workplaces, you may be looking at it for the first time. And so again, just ensuring that you are looking at it through the lenses of applicable laws is going to be important to avoid any claims of discrimination or other retaliation. Next slide. Again, mandates are subject to state and local restrictions, but employers generally can require vaccination. That's going to be harder and harder to do as the numbers are low and your workforce for business reasons may not be one that will tolerate a vaccine mandate, and that's okay too. No matter what you do though, you have to make sure you're complying with exemptions and accommodations as appropriate for disability and religious concerns or for anything else mandated at the state level. And keep in mind that third parties, such as clients or property owners, may implement their own vaccine mandate, and you may have to, deal with a contractual obligation beyond the contract with the federal government, but with another party that may require a vaccine mandate. Next slide. EEOC guidance historically has been pretty clear in terms of encouraging employers to apply ADA reasonable accommodation provisions and ADA to comply with ADA's prohibition on medical inquiries, as well as Title VII religious accommodation provisions and compliance with the Genetic Information Non-Discrimination Act. Next slide. Again, federal laws don't prevent employers from requiring that anybody physically entering the workplace has to be vaccinated, but employers have to comply with the reasonable accommodation provisions and any other EEO consideration, as well as state and local laws. Next slide. So under the ADA, you must show that an unvaccinated employee would actually pose a direct threat to others in the workplace that cannot be addressed by a reasonable accommodation. Depending on where your business is located and the community spread, this may or may not be a difficult standard to reach. Generally, when the pandemic is at its height, the EEOC guidance is very favorable to employers here, but that is continuing to morph as we see the numbers decrease. If no accommodation exists, employers generally can exclude an employee from physically entering the workplace, but we would caution employers not to automatically terminate such worker and instead engage in your standard individualized interactive process to see if there is any other accommodation, including a leave of absence, that can allow that employee to remain employed. Likewise, under Title VII, employees are protected from religious discrimination. So if they have a sincerely held religious belief, they can't be forced to get vaccinated if it legitimately offends that belief. And I will say very few religions have moved forward with actually putting forward the evidence required to establish such a restriction. We know that Seventh-day Adventists have been active always standing against vaccine requirements, but again, even that will require appropriate documentation. And there are some religions that have taken pretty open stands against the religious beliefs requiring someone not to get vaccinated. And so again, some employees may make these claims, but it might not be supported by their religious institutions or other public information. You must provide reasonable accommodations unless doing so would pose an undue hardship. It is a high standard, but again, guidance so far has been very employer friendly as to it providing an undue hardship, but we're seeing that, of course, change with the numbers decreasing. Next slide. So some basics on the interactive process that are always best practices. So keep a reasonable accommodation log and monitor it regularly to ensure you're being consistent with the kinds of requests you're getting from workers across the country, or at least across a particular facility. You want to document contemporaneously all the options that you're suggesting, that the employee is suggesting, why something was denied, and then ultimately what's approved and the outcome, ensuring that you are providing an accommodation at the end if it is available, and that you're not terminating employees until you have exhausted an interactive process that you have documented and fully vetted to ensure that the only option is termination. You want to also plan ahead and be ready for an increase of these requests. Although we see the numbers coming down on COVID-19, that does not necessarily mean you're going to get more exceptions. Some employers have completely halted their vaccine mandates for the time being because the numbers are low, and may, again, if the numbers rise, re-implement it. So for some employers, it's been unnecessary to continue to process and evaluate the notes requiring accommodations and other such requests, but others are continuing with their process because they know this is going to be an up and down situation and they want to keep a consistent practice going forward. Next slide. Employers can also offer incentives, and again, that's not prohibited anywhere by the EEOC. And employers that choose to obtain vaccination information simply have to keep that information confidential pursuant to the ADA. Always has been a true requirement. We always encourage employers to keep vaccination records separate from other medical records because they may not be relevant for your typical benefit analysis. Next slide. So if you are administering vaccines to employees, you can offer those incentives as long as they're not coercive. So again, you're not giving them such a tremendous benefit that they will feel forced to share the information or forced to comply with a vaccine mandate. Because vaccinations also require employees to answer disability-related screening questions, hugely large incentive could again make employees feel forced to disclose medical information that they otherwise would want to keep private. Next slide. The EEOC is encouraging employers to educate their employees as to vaccine, the reality of COVID-19 vaccines, and raising awareness as to why it's beneficial. Technical assistance highlighting federal government resources should be made available to employees that are asking information about vaccination records. So generally, being friendly and open to those that want to get vaccinated is important and has been permitted by the EEOC. Next slide. So the American Rescue Plan Act of 2021 permits federal tax credits for private employers with less than 500 employees. That means employers can voluntarily provide paid sick leave and use those tax credits accordingly. Many states and cities, though, have or are enacting COVID-specific paid leave laws, and others are just employers independently choosing to offer some degree of PTO, again, to encourage workforce compliance with vaccine requirements. You want to review your state and local sick leave requirements, again, to continue to cover any, especially those that have an independent COVID-19 sick leave. You don't want to rob employees of that independent benefit, in addition to what already might exist from a sick leave perspective. Next slide. If you are mandating, you want to make sure you have a written policy that actually provides a process for requesting reasonable accommodations. You want to keep those records separate from general personnel files. Again, you don't want supervisors and others getting full access to vaccine records unnecessarily. You want to maintain confidentiality, and you want to avoid any disparate treatment or discriminatory treatment among employees because of how you're implementing your program. And finally, you always want to train your administrators so that they're following your written policy and applicable law. Next slide. HIPAA rules do not apply to employer employment records, so this is not a consideration for COVID mandates. Next slide. Employers, in addition to what we've discussed, which are some incentives and education, can also just focus on COVID testing and making it free and widely available or required at work. Next slide. Of course, we know that whether or not you implement a vaccine mandate, it could have an impact, positive or negative, on employee morale and retention, depending on your particular workforce. We know that vaccines are not a substitute for still maintaining a safe work environment, so employers should not stop there. And you want to think ahead and develop a process for what to do with those employees that are refusing to comply and are not citing a lawful exemption. You want to make sure that any disciplinary action is clearly communicated in your policy so that nobody is surprised if they're receiving discipline, and you want to enforce it consistently. Again, you want to avoid disparate treatment. That is really where the risk is here for those employers that may have managers making these decisions, instead of making sure they're going through a centralized process and a centralized policy around vaccination. Next slide. A lot of employees may have fear of the vaccines. They might be led by misinformation. There might be political, religious, or medical reasons, but all of these are some potential reasons you might have employees refusing vaccine mandates. Next slide. So if you have a lot of vaccine refusal and you do not have a workforce that you think will end up getting vaccinated, and so you're choosing not to go that route, you can certainly focus on what you can offer otherwise, things such as working remotely, telecommuting, which have been already implemented by many employers across the country throughout the last 2 years, offering personal protective equipment that the employer can provide, such as an N95 mask, mandating social distancing protocols, separating unvaccinated employees from those that are vaccinated as appropriate, right? So if you have some unvaccinated employees who do not want to comply with certain requirements and you're able to do that by accommodating them, you can do that. Increased workplace sanitation is always key, and again, most employers have increased their sanitation for some time now. Having strict masking requirements is another option, although across the country, masking is really, of course, going to continue to decrease given the new guidance from the CDC. Daily temperature checks and reporting is something a lot of employers implemented via apps and other processes, and many are continuing to do that as one step to keep everybody safe. Requiring those that are entering the building and working in the building that they produce a negative COVID test is an option. Some are doing that weekly, monthly, daily, and all of those are appropriate options as well. Next slide. But you want to tread carefully so you're not creating any impracticable precedent. So if you're doing something for an employee that is really bending over backwards, just keep in mind you might be asked to do the same thing by another employee in the future. And so you'll have to know why it's okay for this one employee and not the other. You want to be careful when you're excluding employees from work that you're actually adhering to the direct threat analysis, which requires employers to consider the duration of the risk, the nature and severity of the harm, the likelihood that harm would occur, and the imminence of the potential harm. And of course, because of the lower COVID transmission amounts, we would have a harder time proving direct threat today than we did at the beginning of the pandemic. Next slide. So what are some key takeaways? We know this is going to continue to be a vexing area. Employers are still deciding whether they're going to mandate vaccination or not, whether they're going to get everybody back in person or not, whether they're going to continue testing or masking or not. And those are all valid. And again, those that are federal contractors have additional restrictions as we discussed today. But at the end of the day, the test still remains the same, which is, are you protecting your workers? Are you acting reasonably to protect your workers and reduce the spread of COVID-19? Every employer will react differently based on their population, where they're located geographically, public and political concerns, customer requirements, and impact on reputation. So adhering as much as possible to OSHA guidance, federal requirements, CDC guidelines is always going to help and avoid minimizing risk, but also has to be balanced against your real business needs and the needs of your customers. So you want to seek input from your workforce if you can to predict the risk, to gauge their engagement and ensure high levels of buy-in across the board if you are going the route of a vaccine mandate. And of course, you want to stay vigilant. This is a constantly changing area. We expect that to continue to be the case. So as long as you're enforced and you've identified individuals with responsibility for bringing that information back to your business, then I think you're going to be better situated than those that are not continuing to maintain COVID at the center of their priorities going forward. Next slide. So if there are any questions, my information is provided here, I believe in the next slide. Yes, and so you can feel free to reach out. Our team is happy to connect. And again, we have attorneys across Fox, both in labor and employment and in our government practice groups that can help with any questions that might come up. Thank you very much for your time.
Great. Thank you so much for fantastic information and laying it out in a clear, concise manner. Great. It was great to have you with us. I know you put a lot of time and effort into the slides, the content. It was a great presentation. And as I mentioned earlier, the slides are always available on our slideshare.net site. It's a complimentary download. You've got over 500 complimentary GovCon webinars there. And then today's recording will be available later, within 24 hours, hopefully later this afternoon, on our website and on our YouTube channel. So thanks again, Gray. If you guys have any questions, you've got her contact information here, email and phone number. And that, I believe, wraps it up for us. So thanks everybody for joining us, and we'll see you next time. Thank you.
Thank you.